Good morning, everyone, and welcome back to our weekly webinar series. Today is our 89th episode. Over to Anil, sir.
Thank you, Ankit. I like expecting a lot of questions today because this subject that we have chosen is primarily based on the demand of various our well-wishers and also viewers. So before I start, I welcome all of you to our 89th episode of AAA weekly webinar series. And the subject which is purely a new subject. We have not dealt with this subject before. However, this is very important. See, the various questions which came to me was that the corporate debtor has not given loan to the claimant, and the corporate debtor has pledged or mortgaged one of its assets to the claimant. Loan has been given to another entity. Asset of the corporate debtor is pledged or mortgaged to give loan to that other entity. So the question is whether the claim can be filed before the corporate debtor because there is no loan given to the corporate debtor. Secondly, there is no corporate guarantee given to the lender. So if there is no corporate guarantee, there is no loan, then what is the status of this transaction? And the transaction is that one of the assets of the corporate debtor is mortgaged or pledged to the lenders, and the loan has been given to a third party. Now, we have so far understood that the meaning of the creditor, and there are only two kind of classifications in the creditors. One classification is financial creditor and operational creditor. And the second kind of classification is secured creditor and unsecured creditor. To understand these two classifications, let us first of all see the definitions given in the code. The first definition is the definition given in section 3, subsection 10, and that is the definition of creditor. In this definition, there are four kind of creditors have been defined. That means any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured creditor, and an unsecured creditor, and a decree holder. So basically, decree holder is also a creditor. That is also very clear in this definition under section 3, subsection 10. Going forward, another section 3, subsection 30 defines the definition of secured creditor. And that is defined as a creditor in favor of whom a security interest is created. Then we go to section 331 and the definition of security interest is given. I think we are not dealing with that subject today. Once we are clear that the security interest is created, then today's discussion is applicable. Then we are not discussing the security interest. This is very clear that the security interest has to be there. Then only it will become secured creditor. Now, then we go to section 53, which is the section which actually would be used for distribution of proceeds in the case of liquidation of the company. However, this section 53 is also used in section 30, subsection 4 of the IBC, which deals with the resolution plans. So section 3053 is important. Therefore, it is used in the resolution plans as well as in the liquidation processes. First of all, let us see section 53, what it says about the creditors. Distribution of assets, section 53, non-obstante clause. So after the CIRP cost and the liquidation cost, the first priority is given to the workman dues and secured creditor. Now, the secured creditor, only those secured creditor who has a relinquished security interest in the manner set out in section 52. Now, the secured creditor is the word very clearly not a financial creditor, not an operational creditor, not other creditor, not direct creditor, not indirect creditor. So the definition is only secured creditor. So this is where the secured creditor is basically inclusive of all kind of creditors. It may be financial creditor, it may be operational creditor, it may be other creditor, it may be direct creditor, it may be indirect creditor. So these are the various categories that we have seen now practically in the professional, in the claims, that yes, somebody is not an operational creditor, somebody is not a financial creditor, then it has to be something which is other creditor, direct creditor, or indirect creditor. Mostly indirect creditor, because the direct creditor will come under the operational creditor, or means the direct creditor means that anyone who has given loan to the corporate debtor. Of course, then when we go ahead, then we also see the clause D, which says financial debt owed to unsecured creditor. And the financial debt is defined under section 5, subsection 8, a detailed definition. And in that detailed definition, the corporate guarantee is also covered as a financial debt. Corporate guarantee is also covered as a financial debt. And it was a huge discussion amongst the professionals that once a company gives his own asset to secure a loan given to another entity, that also means that it is a deemed corporate guarantee. However, the Apex Code has actually said in 2-3 times, in 2-3 cases, that corporate guarantee is a specific agreement. It cannot be a deemed agreement. So in case there is no corporate guarantee agreement, then there is no corporate guarantee, there is no promise to pay, and there is no promise to fulfill an obligation. It is only the property which is mortgaged. So in case the lender is not able to monetize that property, then there is no promise, there is no obligation on the company, on the owner of the asset, to make payment to that loan. So this is very clear that when I give corporate guarantee along with an asset, then my responsibility is to make payment. And for making the payment, the lender can take the enforcement right on the security interest. However, when I have only given my property, and in case that lender is not able to recover anything from that property, that lender cannot come back to the company, to the corporate debtor, to claim that amount from other assets of the company. So that is the basic difference between the corporate guarantee and just giving one asset to another entity lender. So Ankit, I think this is very clear. And when I was actually trying to see how this is used in section, how this is used in section 30 subsection 2 in the resolution process, first it is dealt in section 30 subsection 2, which provides that the amount payable to operational creditor should be at least the amount which would have been distributed to them as per the priority under section 53. So this is where the section 53 is being used. So section 53 is also important in resolution process. It is also important in liquidation process. So we can't say that it is only made in. So then section 30 subsection 4. This is actually a very important. Then I say in section 30 subsection 4, this was also amended section. It was amended section. So now let me read this a little carefully, and I would say that this is the committee of creditors may approve a resolution plan. These are the mandatory conditions of resolution plan by a vote of not less than 66% of the voting share of the financial creditor. That means only financial creditor will vote. After considering its feasibility and viability, viability is the responsibility of the committee of creditors. and the manner of distribution proposed. The manner of distribution proposed is also supposed to be seen by the committee of creditors, which may take into account, it is not shall, it is may, the order of priority. Order of priority means whether it's a first charge, it's a second charge, it's subservient charge. Order of priority amongst the creditors as laid down in subsection 1 of section 53. So section 53 is also mentioned because the order of priority is like first it will be CIRP cost, and it is secured creditor plus workman pari passu, then it is unsecured financial debt, and then so on. Including, no, what it is saying at the after in the manner and considering, including the priority and the value of the security interest. The first is the order of priority as per section 53. Then is the priority of charges. Priority of charges like first charge, second charge, subservient charge, and also value of the security interest of the secured creditor. Here, the word is secured creditor. When it comes to voting, the word is financial creditor. Ankit, can you see in the second line, the word used is financial creditor. When we are saying that how the distribution will be made, it is the word used is secured creditor. That means voting will be done only by this financial creditor. However, the distribution will also be given to the secured creditor, and such other requirement as may be specified by the board. So that is something which is very clear. Section 30 subsection 4 gives a power to the committee of creditors, and the committee of creditors may also means should consider the order of priority, value of security, and the priority of charges of each secured creditor, and not restricted to the financial creditors. So in a resolution plan also, the distribution will be as per secured creditor. In the liquidation also, the distribution will be as per secured creditor, irrespective of the fact whether you are a financial creditor or you are an operational creditor or you are an other creditor or you are an indirect creditor. The distribution will be as per the only and only definition, whether you are secured creditor or unsecured creditor. So this is something which is very, very important that I wanted to say. Then of course, the other part of the mandatory contents of the resolution plan is that therefore the code makes a distinction between the financial and operational creditor while simultaneously retaining the conventional classification of being secured or unsecured. Secured or unsecured is definitely there, and the distinction between the financial and operational creditor definitely is also agreed. Now, the following debt shall rank equally between amongst the following is importance. Equally of ranking between the workman's dues and the debt owed to secured creditor. That is what it means when we say the debts ranking equally between and amongst the following. So this is, so now we actually can see the twofold distinction in the section 53. One is secured and unsecured, and the operational and financial. So this part, now we have tried to see that this is one part which is the definitions, secured creditor and financial creditor. So now I think, Ankit, we actually, there are some questions. I can see the raised hands, but I think we can take something forward and then we should take the question. What do you say, Ankit?
Yeah, I think that's that would be great. Yeah, that should be preferred. Yeah,
because see, like there are some more issues that we need to discuss, some more judgments that we need to discuss. Then we will take up the questions.
right.
Then we also now try to see what kind of judicial pronouncements have actually come on this subject. So we actually would like to see a couple of judgments which are like, let us start from one, JR Agro Industries Private Limited versus Swadhisht Oil Private Limited, and not a very new judgment, but then it comes to unsecured creditor, unsecured financial creditors appears in the 4th rank, but unsecured operational creditor comes in the 6th rank. That is where the distinction was trying to operational creditor, and that kind of distinction was defined in this. So therefore, in the NCLT Allahabad, in fact, in this case held that since the term secured is used in section 53, subsection 1, clause B, and there is no indication of the type of debt, that is financial or operational, payable to such secured creditor. So the secured actually means whatever it could be. It could be operational, it could be financial, it could be other, it could be direct, it could be indirect. Therefore, it makes no difference to the treatment of the secured creditor, whether they are financial, operational, or other, and the secured creditors will be treated equally. This is the like way back 2018 judgment from NCLT Allahabad bench. And then we also have this Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited. For some point of time, this particular judgment was considered to be a kind of review of Rainbow Paper. But later on, the Rainbow Paper's own review came, that order came. So still Rainbow Paper is considered to be applicable. So in this case also, the Honorable Supreme Court has tried to place a significant importance and emphasis on the waterfall mechanism under Section 53. So the apex court has defined the payment of debt to secured creditors who waive their security interest in favor of the liquidation, and also said that the workman, and this is all defined something, then the debt owed to a secured creditor, whenever such secured creditor has relinquished security interest in the manner, this is also receives a fairly high priority. This is the observation. Then the code balances the rights of secured creditor who are either financial institutions, service providers, or classified as other secured creditors. Also ensures that the economic activity and revival of a viable company is not hindered because it suffered or fallen into a financial crisis. So the secured creditor actually are being treated at a fairly high priority, and irrespective whether that person has provided security, provided funding or services or goods or other kind of creditors. And then the code also has carefully thought out, give options to secured creditor and balances their interest in whose favor the other creditors in a liquidation proceedings. As we've already said, that the financial creditor and financial debt has been defined in Section 5, subsection 5 and subsection 7. And we carefully see that the financial creditor. So then we see the Section 5, subsection 8, and finally we see the Supreme Court judgment in the case of Pioneer Urban Land and Infrastructure Limited versus Union of India. That is, the judgment came in 2019. So in this judgment, the apex court has already said that the definition of financial debt in Section 5, subsection 8 then goes on to state that debt must be disbursed against the consideration for the time value of money. Now, the disbursement has already been defined in the law dictionaries. So let us start from the concept which has finally come into the Vistra judgment. It started somewhere in 2019 when this Pioneer Urban Law and Infrastructure Limited judgment came, and the disbursement was considered to be a very important part of being a financial creditor. So when we are discussing the case that we are discussing, no disbursement has been made to the corporate debtor. Therefore, it is actually not fulfilling the requirement of Section 5, subsection 8 regarding disbursement for the time value of money. So there is two things are missing: disbursement to corporate debtor, second, time value of money. Because whatever the financial debt would be, that financial debt would have some time value. When I give my asset, when the corporate debtor give an asset to secure the loan of another entity, there is no time value of money for the corporate debtor. There is no disbursement to the corporate debtor. There is no time value of money to the corporate debtor. That's what this Pioneer Urban judgment is trying to say. The act of paying out money, commonly from fraud or in settlement of the debt on account of payable, the money so paid, an amount of money given for a particular purpose. Now, the Supreme Court has also said, because see, these two things are in fact basically taken from the JP Infratech Limited, the IRP versus Axis Bank. Now, in this judgment, the expression means and includes, in fact, has been very kindly elaborated. on the very same principle of interpretation indicated above makes it clear that for a person to become a creditor, there has to be a debt. For a person to become a creditor, there has to be a debt, and that is a liability or an obligation in respect of a claim which may be due from any person. See, that the case that we are discussing, the corporate debtor has not taken any loan. The corporate debtor has only given his asset to secure the loan given to another entity. That means the liability to pay back that loan is not on the corporate debtor. Liability to pay back that loan is on that other entity. So I think this is what we are trying to clear. So it doesn't become a financial debt. Then coming to the secured creditor, section 3, subsection 30 says the security interest is created. Yes, the security interest is created. The asset of the corporate debtor is mortgaged to another lender, and that lender has also created a security interest before the registrar of companies, before CIRP. So that security interest is very well evident that yes, the security interest has actually been created. So the the definition of security interest was discussed in JP Infra Limited, and the mortgage created, any mortgage created in leads to a security interest. However, when all the defining clauses are read together and harmoniously, it is clear that the legislature has maintained a distinction amongst the expression financial creditor, operational creditor, secured creditor, and unsecured creditor. This is what we are saying since the beginning of this webinar today. So therefore, every secured creditor would be a creditor, and every financial creditor would also be a creditor, but every secured creditor may not be a financial creditor. This is what very clearly has been said in this JP Infra judgment. So every secured creditor may not be a financial creditor. That has been said in this judgment. And then finally coming to the judgment, which is the judgment on 4th of May 2023, that is the Vistara ITCL India Limited versus Dinakar Venkat Subramaniam. And this was in the case of MTech Auto, a very large company, and this judgment has come from Honorable Supreme Court. Now, this judgment has actually given a unique class of creditor, that is indirect or other secured creditor. So this particular judgment has, for the first time, they have used the indirect or other secured creditor. So therefore this discussion, therefore this webinar, that what is this indirect or other secured creditor, what are their rights under resolution, what are their rights under the liquidation. So that is what we are going to discuss. And first of all, let us try to understand the facts of this case. So this company, like Amtech Auto Limited, Amtech Auto Limited was basically the company which has two companies, L&T Finance Limited and KKR India Financial Limited. They had actually given loan of about 500 crore to Brasco Engineering and another investment company. So these are the two borrowers. So who the borrowers are, let us try to say the Brasco and WLD. These are the two borrowers. And what is the basis of this loan? Amtech Auto, the borrowers, these are the group companies of Amtech Auto. These are the group companies of the Amtech Auto. So the shares of Amtech Auto, was mortgaged to L&T Finance and KKR India Financial Services to take a loan of 500 crores. So then Vistara ITCL was appointed as the security trustee of the creditors, because this Amtech created a first-ranking exclusive pledge in favor of Vistara, being the security trustee for the creditors over 66.67% of its shareholding in JMT Auto. JMT Auto is a company, again, from the group company. Like Amtech Auto mortgaged the shares of JMT Auto to L&T Finance and KKR, and the loan was taken by Brasco and WLD. Now, the Amtech Auto, in fact, came in CIRP, and the Liberty House resolution plan and everything was, that story, of course, is not really important in this case. And the Then Vistara and the creditors filed an application, NCLT, seeking RP be directed to include Vistara into the COC as a secured financial creditor. That is the first time they filed their claim in the second CIRP process. NCLT dismissed that, saying that they approved the resolution plan of DVI. DVI resolution plan has already been approved. So DVI is Deccan Value Investors. So they said that it is, and they cannot admit. Then NCLT again said the NCLT made some observations. NCLT said that the Vistara and the creditors had not challenged the rejection of the RP of the Vistara as a secured financial creditor of MTech in 27, after which Liberty House Group resolution was approved, and therefore it was not open for Vistara to raise this issue later in 2020. MTech did not owe any financial debt to Vistara, as the creation of pledge did not amount to grant of any guarantee or indemnity by the MTech to the creditor. This was the observation by ANCLAT in this case of Vistara and Dinkar. Now, the word used here by ANCLAT is there is no guarantee or indemnity. Now, this guarantee or indemnity word has been taken from section 5, subsection 8, subclause I. There is, in case there is a guarantee or in case there is an indemnity, that means it is a financial debt. So ANCLAT is first in said that there is no guarantee or there is no indemnity. Therefore, there is no financial creditor. Now, because of this, the Vistara went to Supreme Court of India. Now, the Supreme Court of India, in fact, they had to deal with basically two legal issues. One, whether Vistara and creditors be treated as secured creditors. Vistara and creditor, the word is being used only because the Vistara is a trustee and representing the creditors. So therefore, the Vistara and the creditor word is being used, whether they should be treated as secured creditors. And secondly, what would be the treatment of rights of a secured creditor who neither fell under the category of financial creditor nor under the operational creditor. So this was the two questions with the Honorable Supreme Court. Now the Supreme Court says treatment of indirect secured creditors during CIRP. Indirect secured creditors are not defined under the IBC particularly. Normally, a secured creditor is an entity that lends money to the corporate debtor and some assets are pledged with him as a security. That is what is the normal definition of a secured creditor. And in this, in the Honorable Supreme Court, the new concept of indirect secured creditor was, in fact, is something which has come into this particular judgment only. Now, in this case, it is saying that the corporate debtor utilized its assets as collateral to secure the loan given to another company, other entity. These creditors do not actively participate or engage in the corporate debtor's operations. Their sole interest lies in selling the pledged shares. In this case, it was shares. Now, in some cases, it can be some property. It can be any asset. So, this is a case where the shares owned by the corporate debtor was pledged to give loan to another entity. We might have cases where the properties, real estate properties owned by the corporate debtor is mortgaged to lenders to secure the debt given to other entities. So it is absolutely similar. There is no difference in the definition of asset. Shares are assets. Similarly, real estate is also asset. So now, in this case, the question of law in the case with dealt with by the Honorable, whether the legal provisions or considerations govern the treatment of indirect secured creditor during CIRP, when there is no specific provision offering them special treatment concerning the mandatory contents of a resolution plan. So this was a question of law, whereas I have already said that the secured creditor, section 30 subsection 4 says that the secured creditor, the committee of creditors will decide how much to be given to each claimant. However, the committee of creditors may consider the priority under section 53 and also the priority of charges and the value of security interest while allocating proceeds of resolution plan to the claimants. Now, there is no specific reason. However, the Supreme Court says treating indirect secured creditors as financial creditor of the corporate debtor up to the amount of estimated value of the pledged share, that was one option. This was also discussed in this particular judgment. One alternative is that we can consider the indirect secured creditor as financial creditor to the extent of estimated value of the pledged shares, thereby making them a member of the committee of creditors and give them voting rights. However, this proposed alternative is surrounded by myriads legal issues. There are various legal issues which will come up in case we consider these creditors as financial creditors. Now, the first difficulty would be, first of all, there is no debtor-creditor relationship and the absence of time value of money, which has actually been held in the case of Anuj Jain IRP for JP Infratech Limited versus Axis Bank that we've already discussed. The Supreme Court has held for an entity to be classified as a financial creditor as per section 5 subsection 7 of the IBC, the relationship between the financial creditor and corporate debtor must exist primarily, and financial debt must have been taken by the corporate debtor from such creditor. So the first of all, the primary threshold is that first of all there should be a relationship of a debtor and creditor. However, the example that we are discussing today, the property of a particular company is mortgaged to lenders to secure a loan given to another entity. So there is no relationship of debtor and creditor between the claimant and the corporate debtor. It is further the Supreme Court says that it is well settled that the financial debt must involve the essential elements of the time value of money, because see, there is no interest which is coming on the corporate debtor. There is no time value of money to the corporate debtor. Whatever interest is being paid, that is being paid by the other entity. So there is no time value of money in this case. This means that the financial creditor must receive something extra besides the principal amount from the corporate debtor over a specific period. That extra is not coming. The corporate debtor has only given one asset to another entity, and that nothing other than asset, whatever is recoverable from that asset, that lender will recover. In case the lender is not able to recover, then that money, there is no recourse on the corporate debtor. There is no recourse. So when there is no recourse, that means there is no guarantee, there is no indemnity. When there is no guarantee, no indemnity, that means definition of section 5, subsection 8 is not applicable on this particular example that we are discussing. Then the second question, a pledge of share does not constitute financial debt. Pledge of share or even mortgage of a property, both, does not constitute financial debt. Now, in this case, coming to this judgment again, it was argued that since the corporate debtor has pledged its share to secure the loan given to a third party, it shall be treated as a guarantor. And this guarantee would fall within the umbrella of financial debt under section 5, subsection 8, clause I, as I said already. The said argument is completely untenable as a fundamental difference exists between the pledge and a guarantee. Fundamental difference between pledge or mortgage, one side, the other side is a guarantee. So there is no guarantee, it is only a pledge or a mortgage. Simply a pledge or mortgage doesn't mean guarantee, because the Supreme Court has already said in Phoenix ARC Private Limited versus Kettle by Ramubai Patel, and this was said long back in 2019, and it was said that contract of guarantee involves two essential elements. One, a contract to perform the promise or discharge the liability. So these two elements are missing in this transaction. There is no contract between the lender and the corporate debtor to perform a promise. The asset has been given, you can recover from that asset. There is no further contract. Discharge the liability. There is no liability of the corporate debtor to discharge that loan. So therefore, a pledge Therefore, a pledge or a mortgage cannot be equated with the contract of guarantee, as the liability of the corporate debtor herein is restricted to the extent of the pledged share. In the event of default by the borrower, the indirect secured creditor has a limited right to sell such shares or property which does not necessitate the corporate debtor to perform a promise or discharge the liability. So, Ankit, it is very clear, this particular judgment, Vistra versus Dinkar, it's actually very clear. Even the options were discussed. In case we do this, then what are the legal hurdles? In case we do this, then what are the legal hurdles? Going forward, now again, this particular judgment is discussing unique status of financial creditor cannot be extended to indirect secured creditor. Now, the apex court is trying to differentiate between the unique status of financial creditor and the indirect secured creditor. For this particular classification, for the elaboration, the Supreme Court has relied upon their own decision in the case of Swiss Ribbon Private Limited and others versus Union of India. In that case, the apex court held that in scheme of IBC, the financial creditors enjoy a unique status owing to their involvement from the very initial stages with the corporate debtor. Financial creditors are those who are involved with the company from the initial stages. They would understand ins and outs of the company. They would understand the economics of the company. They would also understand how to resolve. Therefore, they have been given the unique status of a financial creditor and to participate into the committee of creditors and to approve a resolution plan or to reject a resolution plan. That unique status has been given to financial creditor. And in case it is extended to the indirect financial creditor, indirect secured creditor, not financial, indirect secured creditor, let us see what the court says. The interest of indirect secured creditor is limited to realizing the security interest and recovering money from the corporate debtor, nothing else. This case, in the Anuj Jain judgment, observed that the indirect secured creditor have a remote connection with the corporate debtor, bereft of any long-term objective of revival and growth, and they shall not be accorded the unique status of the financial creditor. That is something which is completely clear, that the relationship of these lenders is only to recover their money, totally bereft of any long-term objective of revival or growth of the company. Therefore, they cannot stand shoulder to shoulder with financial creditors. Now, treatment. What would be the treatment of indirect secured creditors during liquidation? Now, giving their rights and entitlements as provided to the secured creditors very clearly under Section 52, this Vistra ITCL India Limited, it is in this judgment, it is said that the secured creditor will have the right to invoke Section 52 and do not relinquish their security interest in favor of the liquidator in case the company goes into liquidation. So they can actually sell their own pledged security outside the process of liquidation. Now, let us try to understand the said observation has raised several concerns. Now, the Supreme Court has said the IBC does not envisage special protection for such indirect secured creditor at the stage of CIR. In liquidation, they have that protection. However, in the CIRP, when this judgment came, actually, when this Essar Steel judgment came, the Section 30 subsection 4 was not there. Section 30 subsection 4 came later. However, in this particular judgment, during CIRP, it is noted that the secured creditor as a category fall under the broader classification of financial creditor and receive substantial protection. However, indirect secured creditors not categorized as financial creditor due to their restricted involvement in the CD's affairs, providing them with an elevated level of protection would be illogical. That's what was held in Essar Steel Limited versus Satish Kumar Gupta. That was long back in 2019. And after that, we actually have received this Section 30 subsection 4 amendment in IBC. Now, coming to the another question, restricting preferential treatment of secured creditor in liquidation to direct secured creditor under Section 53. So, in this case, I believe the court is again taking taking whatever was held in JP Infratech, and in the case of Anuj Jain, So again, Section 52 is applicable to secured creditors. They actually have a right to not to relinquish their security interest, and they have a right to enforce their own security interest, recover their money. And however, the the financial creditors, it is held, whereas the later means the financial creditor, like see, these indirect secured creditors, they are not involved in assessing the viability nor lending any money to the corporate debtor. Therefore, putting them on an equal pedestal would do more harms than good. So the Supreme Court is very clear that these lenders, they cannot be put on the same pedestal where the financial creditors are standing, because they have no involvement in the uh, corporate debtor. But there was another issue which came. Now the question came that the clean slate theory. Now suppose MTech Auto has pledged shares, and the shares were encashed by the other lender, and the loan was given to the other entity. Now in this case, the when this amount is recovered from the shares, then the resolution applicant will have the right to recover that kind of money from the entity for which the shares were pledged. However, in this particular case, the clean slate theory is not applicable, because because we are talking about MTech Auto. So MTech Auto will definitely go clean to any other person who actually is a successful resolution applicant. But the successful resolution applicant can recover that kind of money from those entities for which the share assets of the company has actually been enforced and it has been sold. Now coming to the voting rights vis-a-vis the other secured creditor. The Section 21 says that the IRP shall constitute committee of creditors. The committee of creditors will comprise of all financial creditors. Where the corporate debtor owes financial debt to two or more financials than the consortium, Section 21 does not talk about the secured creditor, but it is only the financial creditor. So if someone is a financial creditor, will become part of the committee of creditors. If not a financial creditor, then will not become part of the committee of creditor. This is very clear. Accordingly, the financial creditor is a secured or unsecured will become COC members. On the other hand, all other secured creditor, including the secured operational creditor, other secured creditor, or indirect secured creditor, will not have any voting right into the COC. So the finally conclusion in this case was that yes, the pledge of shares, pledge of assets, mortgage of the assets of the corporate debtor to facilitate loan to other entities, the claimant will become other secured creditor or indirect secured creditor. They would not be able to participate into this committee of creditors, because the committee of creditors is restricted to financial creditor. Financial creditors are supposed to be those financial institutions who are involved in the company. They are involved in the growth of the company. They have seen the company right from the beginning. So these creditors have a limited interest of enforcing their own security interest, monetizing that security. And in case they are not able to monetize that security interest, that secured asset, then they would have no recourse on the corporate debtor. Therefore, their status would be indirect secured creditor. I think now we can take up some questions, Ankit.
So I am just opening up the questions. Now I will start with the first question that came in. So Ritesh Shahji is asking, ABC Private Limited corporate guarantor has given corporate guarantee for loan lent to XYZ Private Limited. Corporate guarantor is admitted to NCLT, and simultaneously or later to that, XYZ is under default, or later to that XYZ is under default, will lender of XYZ be treated as FC as they invoke CG later to ABC admitted to NCLT? I believe there's a problem
Yes,
with the
I think
question.
what I could understand about the question, that this is a question regarding the corporate guarantee.
Mhm.
Now, the corporate guarantee is I consider to be a financial debt. Section 5, subsection 8, clause I. The only condition is that the corporate guarantee should be invoked. So, I mean, even if in some cases I have seen, then even if it is not invoked, a corporate guarantee would be entitled to a claim to the IRP, and IRP will admit that, and it will be considered as a financial creditor. So in case any of the asset of the corporate debtor is also mortgaged, then it will become secured financial creditor. And in case there is no asset of the corporate debtor is mortgaged, it is only a simple corporate guarantee, then it will be unsecured financial creditor. So this kind of clarity is very clear. I think we can even see, in case Ritesh is raised hand, in case he can speak, and we can take
So I think
him.
I think Ritesh is only talking about a change in the events. He's saying that the primary borrower XYZ Private Limited has not defaulted when ABC, which is the corporate guarantor, has been admitted into NCLT. I think the question is that if XYZ is not in default as on the CRP date, but the corporate guarantor for XYZ's loan uh, has gone into NCLT, will the
I think
person holding,
we can ask from Ritesh Shah.
yeah, yeah.
Ritesh ji, in case you can just
Ritesh ji can
elaborate your
unmute.
question.
Yeah, Ritesh ji
Yeah,
can unmute and
Yeah,
yeah,
now audible.
yes,
yes,
yes.
very much.
So my question is that whether the corporate my borrower is under default or not in default. Maybe one situation my borrower is in default, but I have not invoked my corporate guarantee. But later that corporate guarantor is getting admitted to NCLT, CRP started, and I am filing my claim as a FC. And subsequently, I am means before filing my claim, I am invoking my guarantee. But that is later to NCLT admitted this corporate guarantor.
No, I think see, there are like I will give you an example.
Hmm.
Now, one company, and there are five lenders.
Hmm.
Maybe out of the five, two or three loans are bad, and the rest of the loans are still standard.
Hmm.
When the company goes into CIRP, everyone is supposed to file their claims, even if
Hmm.
it is a standard, or even if it is a NPA, or it is a defaulted account. So, similarly, in the case of corporate guarantee, when my loan is standard, I have not invoked the corporate guarantee, and the company has actually gone into insolvency, then everyone will file their claim. So the corporate guarantee as such is covered under Section 5, subsection 8, clause I, and it is not really required that your debt, it is not really required that your debt also should be bad. You can still file your claim as corporate guarantee. In case you have a specific asset on which the mortgage or charge is created, then you would be secured financial creditor. Otherwise, you would be unsecured financial creditor in the CIRP of that company.
And in the claim, and in the claim, one can easily say that this is against a corporate guarantee, and the primary debt is not under default. And I believe the RP will be, or IRP will be, duty bound to admit the claim under that specific category, right?
No, I'm saying, like, even if the debt is not under default,
Then
wherever
also there
there
is
is
a
a,
liability.
it has to be a
But
claim.
invocation of the guarantee is not mandatory.
Claim has to be filed.
Yeah,
Claim has to
No,
invocation
be.
is
but
not
before a file
invocation is
claim,
not mandatory.
Yes, yes, please.
So the question
I
is
think
invocation mandatory before filing the claim?
No, invocation is not mandatory before filing the claim, because the corporate guarantee is covered as a financial debt. As I have given you the example, there may be three loans which are standard, but if the company goes into CIRP, everyone is supposed to file their claim. So that is what.
in MTech Supreme Court decided differently. I will forward that judgment to you.
No, but that's a different judgment. Maybe that we are talking about this Vistra ITCL.
Not Vistra. There is another judgment also in MTech Auto itself.
Okay. So this is like and the Supreme Court said that it was not invoked.
Yeah, it was invoked related to company got admitted to NCLT.
No, see, in MTech, many things have happened because the most of the claims were in fact before the Supreme Court when the resolution plan was approved. So that was also a consideration before the Honorable Supreme Court. Like in case we do it now, then it would be disturbing the entire the resolution process because it was earlier gone to Liberty, then it went to another company, and finally the resolution plan was approved. So I know the judgment that you're talking about, but then the Supreme Court has finally in that case, it said that we don't want to interfere. But then my understanding is that for any other case, even if the corporate guarantee is not invoked, the claim can be submitted.
Got it.
Yeah.
Thank you, Riteshji. The next question is from Anil Sharma-ji. Anil Sharma-ji is asking, what enforcement is possible on CD by a bank which has deposit of such collaterals if there is no obligation to pay? It is merely a deposit of papers. It is merely a lien.
So the mortgage is a security interest. So whenever there is a security interest, the enforcement of security interest is also applicable. The loan has been given to any other entity. However, the lender cannot recover more than the loan amount. The recovery remedy is available under SARFAESI law. And in other cases, in case the company is into liquidation, then the Section 52 can be invoked, and the security interest can be monetized, can be enforced, or the liquidator can sell those assets and then distribute it to them as per Section 53. So all these remedies are available.
Then we have Mr. Rajesh Goel saying that in case of insufficient value of security asset, whether all secured creditors having first, second, and subsequent charge will rank pari passu equal or not.
So this is something which is still pending. With this particular subject is pending before Honorable Supreme Court in the case of Technology Development Board versus Anil Goel. That judgment came from NCLAT, and as per that judgment, there is only one category of secured creditor, and irrespective of the first charge, second charge, or irrespective of the value of security interest, because there is no mention in that section. So therefore, the NCLAT said that once a secured creditor is a secured creditor, maybe the security with the value of security is only 1% or 100% or more than 100%. On the other hand, whether he's got a second charge, third charge, or first charge, the Section 53 says that once a person is a secured creditor, it will have that priority, and it will have that priority means that it will have complete pari passu allocation from the sale of assets. However, that particular judgment has been stayed by Honorable Supreme Court, and the Supreme Court is not adjudicating that subject and maybe waiting for an amendment in the Act. So presently, that matter is pending before this.
But while that NCLAT judgment is stayed by the Supreme Court, the NCLT judgment, which was overruled or which was reversed by NCLAT, perhaps will prevail, where these charges or first, second, and third charges, and that should be considered. Will you agree with that, or you think that there are other?
There are different views in the professional circle, and some says that once the judgment is stayed, it would not be operational. It will not be applicable on any other person. However, now as an RP, we have two things to rely on. One is the same case, the NCLT judgment from Ahmedabad NCLT bench, and the other is the Insolvency Law Committee report dated 26th March 2018, where the NCLT report has very, very clearly mentioned how the assets, how the proceeds will be distributed amongst the secured creditors in paragraph number 26.1 to paragraph number 26.7. Anyone can read that. At AAA, we have been distributing the assets as per the directions, as per the law, which is mentioned in the Insolvency Law Committee report dated 26th March 2018. So any liquidator can take its own legal opinion. We have taken legal opinion, and we have been advised that it is the liquidator can decide whether to go by NCLAT order or to go by the Insolvency Law Committee, because in case we see the rationality is more and more, because to support this Insolvency Law Committee report, already there is a judgment from Supreme Court in 2005 in the case of Sidco Leather versus ICICI Bank. Now, in that Sidco Leather versus ICICI Bank, which was earlier winding up a case and under the Companies Act, exactly same issue was handled, and the Supreme Court has held that the priority of charges and the value of security interest will be considered by the official liquidator while distributing the proceeds of assets. So therefore, we have two things: Sidco Leather versus ICICI Bank, Insolvency Law Committee report, and NCLT order. So we are actually getting an opinion from the lawyers that you can distribute as per Insolvency Law Committee report, after taking an undertaking from the lenders that in case the Supreme Court decide other way, then the appropriate readjustment in the distribution will be done by using Regulation 41 of the liquidation process regulations.
Then there's a question from the question which says, what will happen in case the CD's shares are extinguished? I think this must be pertaining to the pledge of shares that you were discussing. So in case the
that's what I'm saying. That the CD's shares are extinguished means any pledged shares are extinguished. If the pledged shares are extinguished and there is no corporate guarantee, then the lender has got no recourse on the corporate debtor. So there is no claim on the corporate debtor. If there is a claim, and that is only restricted to the value of that security interest.
Then there's a question where it's a case scenario. A company has given pledge of shares and corporate guarantee to the extent of pledge of shares for loan given to other company. The company who pledges the shares admitted to CIRP, where the pledge of shares and corporate guarantee would be treated as secured financial creditors. So I think there are two parts to the same thing. So pledge of shares is a different contract. Corporate guarantee is a separate.
Pledge of shares with the corporate guarantee. However, the corporate guarantee is restricted to the value of those shares. So therefore, it will be a financial debt, because the corporate guarantee is covered under Section 5, subsection 8, clause I, and the value of the shares would be considered as the value of the claim.
So value of shares as on a particular date, or value of the share
as on a particular date when the claim is being filed.
So in that case, if the shares are not having any value, then the corporate guarantee will also not have any value.
Yes, but then again, that particular matter is pending with the Supreme Court, whether based on the security value of the security interest or pari passu based on the claim. That is something which is pending.
The same matter comes back, but then mostly it will be like that. So you're of the opinion. So when the corporate guarantee happens in this kind of a scenario, is the corporate guarantee not understood to be the value which was the value of the shares as on the date of pledge?
No, the corporate guarantee, if the corporate guarantee is there, and if the value of the security is 0, then it will be considered as secured. However, while considering the allocation, the liquidator, in case the liquidator will follow the Insolvency Law Committee report, the liquidator will not distribute anything to that particular person.
Distribution is a separate idea, that yes, distribution can be
secured.
So that's understood. So what process is required by private secured creditor to sell secured asset and collect loans given? So I think we're talking about liquidations. In liquidation, you have two options. One, you can relinquish the security and allow the liquidator to collect the proceeds and distribute based on Section 53 waterfall. Alternatively, you can choose not to relinquish your security. In case you do not relinquish your security and you are a private secured creditor without rights under SARFAESI, you might have the option to go to the court, seek the exercise of the mortgage.
I think there are
right?
we can talk about Regulation 37. We have Regulation 37 in the liquidation process regulation, which talks about realization of security interest by secured creditor. And there is a process defined in this entire regulation, and this particular process is applicable to all those private financiers where the SARFAESI Act is not applicable.
Okay.
So there is a complete process which is defined in Regulation 37. I think we can go through that regulation, and because this particular regulation is only for other than the SARFAESI entitled lenders.
So Ranjan Chakrabarti is asking, what will be the ranking of secured creditors after the relinquish? If there is second charge, how the situation will change? I think we've already taken care of this. With respect to ranking of the secured creditor after the relinquish, of course, they have the top priority under Section 53, because after the relinquish, they have that priority in line with the wages. If financial creditor has funded corporate debtor by creating security interest over personal assets of the corporate debtor, for CIRP of the CD, that FC would be considered secured or unsecured. So as I think he meant personal assets of the promoters.
The personal assets of the promoter.
So the security is on personal assets, but the claim is against the CD. So unsecured.
Unsecured financial credit.
So in liquidation, bank has relinquished charges on CA value is rupees 10 lakhs. In liquidation, bank has relinquished charge on CD value is 10 lakhs. If it has other assets of guarantor and one finance company has given, not very clear. We have another hand raised. Maybe we can allow that person to speak and have that question as well.
I think we couldn't understand the name. It is V.A. Samu, and we, in case you can unmute yourself and you can explain your question, please.
Sir, good afternoon. I am Murugesan from Chennai.
Yes, good afternoon.
Yes, sir. Sir, in one of the liquidation case, the bank is having a charge on the current assets.
Right.
The realized value was only around 10 lakhs.
Right.
The CD is having one corporate office. Against that corporate office, one finance company has given a loan of 3 crores.
Right.
The property was realized for 2 crores by auction only. Now, bank is demanding equal proportion on the sharing of these 2 crores realized amount. A dispute
I can understand this is the exact matter which is pending before Honorable Supreme Court in the case of Technology Development Board versus Anil Goel, and that matter is still going to take time because probably the Supreme Court is expecting some change in the law before they pass the order. For the time being, in case you would not distribute as it is being asked by the bank, then definitely bank will go and file an application. And in some cases, I have seen the NCLT has also given order as per the NCLAT order.
Actually, it went to NCLT. NCLT has given a ruling that after extinguishing the rights, relinquishing the right, you cannot ask for priority. And then now the case is pending with the NCLAT. What I want to know is, if bank is having a charge on current assets only, the value is only 10 lakhs. And for this finance company, they are having exclusive charge on the corporate debtor. Corporate debtors are only assets.
Right.
Shall I proceed on? Now I am keeping the money in the bank account since there is a dispute raised to this. Now the case is in NCLAT.
I think once the case is before NCLAT, at this stage, you should not distribute. or
Yes, sir.
whether the NCL80 NCLAT has given any directions or any stay?
No, sir, no stay was given, but it's only the hearing stage only.
The NCL80 NCLAT will also kind of wait for such decision. But I have seen in other cases, NCLAT will continue to take the same opinion as the NCLAT has taken in the case of Technology Development Board versus Anil Goel, because in case they start taking a different view, then that means that the appeal before the Supreme Court will have no meaning. So NCLAT will continue to say that all the secured creditors will have pari passu allocation of all the proceeds, whatever it come from, whatever asset. But that particular way of distribution will disturb your lenders. I think it is better not to distribute the funds and wait for the judgment. That's what I can say.
Okay, sir. Thank you. Very nice, sir.
Yeah. We can conclude, Ankit, or there are some more questions you feel, because we already
there are questions, so but I think we can conclude. And there are some other questions, but I think we can take them offline. I will request those whose questions I could not take up to maybe take it up with us offline. Otherwise, we will be spending a lot more time and extend the time beyond 1 hour.
Yeah.
So thank you, everyone. Thank you for joining in today, and thank you for once again to join us every week as this one. Thank you.
Thank you very much. Thanks a lot.